our most fun episodes, Jeff, I thought, was our interview with Ross Guberman in episode 33. Ross is a treasure trove of briefing advice, and that was in episode 33. So refer back to the full episode here. But here were some of the highlights that I recalled from our conversation with Ross Guberman. We talked about how all judges have 3 key fears we should try as advocates to try to tap into those fears that judges have. They are the fear of misconstruing a doctrine or statute, the fear of creating new duties, rules, or defenses in their judicial opinions, and the fear of reaching an unfair result or causing harm to a litigant. So try to tap into these fears when you're writing your next appeal. See if you can tap into them and either spark or allay those fears as the needs of your case dictate. Another tip from Ross Guberman is about discussing bad facts with confidence, not out of defensiveness. Judges and coyotes both can smell fear. But unlike with coyotes, you don't want to try to haze a judge, but you definitely don't want to act like you are fearful of certain facts, and you certainly don't want to just plain ignore bad facts or downplay them. That all looks defensive. Take the bad facts head on and explain why you win anyway. Another tip from our conversation with Ross Guberman: remember, the purpose of legal writing is to help judges organize their thoughts. Briefs are a tool, but aspire to make them tools that are a pleasure to use. So try to give them the information they need, but sometimes they don't like to just this isn't just a toolkit. It's not just hammers and nails. Try to make it a pleasure. If you use a good turn of phrase, try to avoid jokes. Humor is sometimes not well taken in legal writing, but there are still ways that you can make your writing pleasurable to read.
Right.
So we did talk about using clever quotes and flourishes. Remember, business before pleasure. Nail the organization and analysis first. Mastery of style comes later and with great care. That's why Ross reminds writers of the old advice to kill your darlings. Find the line in your brief that gives you the greatest satisfaction when reading it back, and then delete it.
Yeah. You want your brief to... You need your brief to stand out, get attention, especially if it's a writ petition. You want to get attention, but I guess you don't want the writer to get the attention. You want the legal issues and arguments to get the attention. It's a fine line.
It is a fine line. What do you think about the kill your darling rule, Jeff? Do you use that? Do you ever find anything when you read it back and say, I really like that line?
I'm hard to satisfy. When I get to the final brief, that I'm ready to submit, I still think there's areas that could be fine-tuned. It's the rare day where I look at that, God, I really enjoyed reading that back. I have a very critical eye, and so I don't find many darlings. This is not an issue that I typically have in my briefs.
Yeah, no, I do like writing, and I like aphorisms. I like putting aphorisms, pithy remarks in my writing, and so I try to put my I guess sharper edged aphorisms in my non-legal writing. So if I'm writing essays or book reports or something, I'll put that up on a blog or on LinkedIn or something, and try to scratch that itch there and leave them out of my briefs.
Right.
Okay, and then on episode 51, we had another one of our great conversations with Justice James Lambden, a retired Court of Appeal justice from the First District. I just really love this line that Justice Lambden had describing litigation. He said, litigation is not like preparing for a battle. It's more like going on an expedition, like taking a trip across the mountains and encountering different places where you have to do different things. And the reason I put that in the outline here, Jeff, under briefing and advocacy tips, I thought it was just kind of a great high level type of a way of thinking about your advocacy in general. That everything about what we do in persuasion is like taking a journey. It's like trying to take the judge that you're trying to convince on this journey with you through the facts. It's kind of a metaphor for showing and not telling. You don't need if you're trying to use adjectives in order to bring your your judge to your conclusion, you're doing it wrong. You need to take them on the journey with you. You don't get to magically teleport them to the conclusion by way of adjectives and adverbs.
Right.
Another one of Justice Lambden's tips was have an elevator pitch for your case. If you only have arguments but no theme, you're not ready to sell your case. Again, I thought that was another great tip for advocacy in briefing in general. If you're going into your brief without really knowing what your case is about, maybe you're not ready to put pen to paper yet. You should know the theme of your case before you try to craft your arguments. And maybe abandon themes that were adopted at the trial level and tune them better and switch them if they didn't work at the trial level. That's right. That was a tip that Justice Thompson had for us. We'll come to a recap of his tips as well. And then Justice Lambden had this bit of wisdom about the vexing problem of what to do about unpublished opinions. We talk, this is one of my hobby horses, Jeff. What do you do when you find that great case on all fours? All the facts are there, the law is there, but it's unpublished. Justice Lambden says, who cares? The California Court of Appeal is not bound even by published decisions. So even if it was published, it's not like it's going to save the day for you. There's no horizontal stare decisis in the California appellate system. If you find good legal reasoning, whether it's in a published or unpublished opinion, use it. If the good argument comes from a published case, then make the argument and cite it. If the good argument comes from an unpublished case, make the argument, but don't cite it. In either event, it's not the best citation, but the best argument that wins. And Jeff, this reminded me of what one of my favorite quotes, kind of in my. I tried to memorize this. I haven't been able to commit it completely to memory yet. But it's Johann Scotus. Authority sometimes proceeds from reason, but reason never from authority. We should not opinion. This was one of the early church fathers. We should not allege the opinions of the holy fathers unless it be necessary thereby to strengthen arguments in the eyes of men who, unskillful in reasoning, yield rather to authority than to reason. I thought that it just reminded me. Justice Lambden's comment reminded me about this because he says, it's not about the authority. You're not trying to arm wrestle the judge into believing your arguments. You want to persuade them into believing your arguments. Or at the least give them comfort in terms of allaying their fears that at least other people have either in published or unpublished decisions come to the same line of thinking. So the decision maker here would be in good company. Right.
You have just listened to the California Appellate Podcast, a discussion of timely trial tips and the latest cases and news coming from the California Court of Appeal and the California Supreme Court. For more information about the cases discussed in today's episode, our hosts, and other episodes, visit the California Appellate Law Podcast website at calpodcast.com. That's calpodcast.com. Thanks to Jonathan Caro for our intro music. Thank you for listening, and please join us again.